everyone, welcome back to the channel. This is Revathy. Today we'll be discussing about the topic Legal Procedures Part 2. Firstly, let us discuss about the dying declaration, which is a statement that is written or oral given by the person who is in dying bed because of some unlawful act. And this statement will depict the cause of death according to the section 32 IEA. Here we'll come across a term called compos mentis. This means that a person, before giving the dying declaration, he should be certified by the doctor that he is conscious and mentally fit. One more thing is if the dying person is unable to speak but he can make some signs and gesture, then to the questions he can answer with the help of these signs. This is recorded and stated as verbal statement. One thing that you have to remember is magistrate should be present in dying declaration. But if he is not present, it is emergency, then the two villagers or witnesses can be present and taken as a record. But the evidential value will be less. And here it is not necessary that a person should take the oath because of the belief that a person in deathbed will not lie and no leading questions are asked. Now, dying deposition. This is a statement given by the person in the dying bed, but here oath should be taken and this recorded by the magistrate in the presence of accused or the lawyer. Here the lawyer is allowed to cross-examine the witness, but this process is not at all followed in India. So next, going to the oral evidence, where the statement that is given by the witness which he has actually seen in the court or which the court asks him to relating to the investigation. Here the oral evidence is considered to be more important than the documentary evidence. And though if documentary evidence is present, oral testimony is necessary to prove in the court. According to the section of 60 IPC, the oral evidence must be direct. But there are some exceptions, like you can take the example of dying declaration, where it's not possible for the dying person to give direct evidence, right? And an expert opinion, where the author of the book, take the example, it is if he is dead or it is impossible for him to come from so long, then it's not that necessary to be present. Next, doctor's evidence. If his evidence is already recorded in the lower court and attested by the magistrate in the presence of accused, then the record itself can be accepted in the high court. It's not necessary for him to be present. The same for the evidence given by the witness. But if in case there is any doubt to be clarified by the opposite attorney, then they have to be present. Next is the evidence by the MENT officer or officer of Indian Security Press. According to the section 292 CRPC, it's not necessary for them to be present. Next, reports given by certain government scientific experts. Like it can be chemical examiner, chief inspector of explosives, director of fingerprint bureau, or director of state and central forensic laboratories, and so on. It is not necessary for them to be present for every report. But if suppose the opposite attorney wants the experts to be present and they want to ask some question, they can, and they have to be present. Next is the public records. Public records are something like birth or death certificates or marriage certificates, something like that. As I told you before, documentary evidence require oral testimony, but in this is the exception because these are the certificates provided and it is valid. Hospital records, like you can take the example of routine entries like date of admission, discharge, pulse rate, temperature, treatment that is given. All these records also doesn't require any oral testimony. Next, coming to the witnesses. Here the person who put forth their facts of evidence in front of the court are considered to be witness. Here the section from 118 to 134 of IEA deals with the witnesses. Especially in 118 case tells the people who are to be testified. The people who are incompetent, who cannot answer the questions, like extremely old age people or too young or with disease, cannot be made to testify under the section 118. Next, the types of witnesses. Firstly, common witness or witness of facts or occurrence witness, where the witness actually tells in the court what has actually been happened, like what he has seen actually. For this, he requires only common knowledge and intelligence, nothing more to do. This principle is called first-hand knowledge rule. He should not add any colors to what he has seen. He should just able to perceive what he has seen and explain the same in front of the court. Next, the expert witness. Here the person will be skilled and trained. Opposite to that of the common witness, he will have some more knowledge in a particular technical or scientific field. Here he'll be able to interfere or think logically to make conclusions and opinions. Example, firearm expert or a doctor, where, or a fingerprint expert, where if suppose a fingerprint is present, he cannot just tell there is a presence of fingerprint, but he has to actually interpret whose fingerprint are they, right? So this expert test witness comes under the section 45 IEA. One more thing, of 45A section of IEA deals about the opinion of electronic evidences examiner, where this has been asked in the previous year paper. So just remember, 45A is expert for in electronic evidences. Next, coming to the hostile witness. Who is a hostile witness? A person who tries to modify the evidence and gives partially a false evidence or completely false evidence is hostile witness, which is punishable under the section of 191 IPC. That is, we'll see here, perjury, like giving a fabricated evidence to falsify. Under the section of 191 and 192 IPC, it is an offense, and they are punishable up to 7 years of imprisonment under the section of 193 IPC. Before giving any oral evidence, a person should take the oath. He takes oath as, I do swear in the name of God that what I shall state shall be the truth, the whole truth, and nothing but the truth. But if he is an atheist, he doesn't believe in God, then he solemnly affirms. In the section 51 of IPC, if a child is below 12 years, it is not required for it to promise or take an oath, because it is believed that child doesn't lie. And coming to the procedures in examining the witness in a court of law according to the section of 137 IEA. Firstly, it starts with examination in chief, where the witness is questioned by his own lawyer or advocate. According to the section of 24 and 25 CRPC, if it is a criminal case, then firstly the public prosecutor examines the witness. Coming to leading question, according to the section 141 IEA, a question that suggests the particular answer from the witness with a conclusive answer of yes or no only. Here, suppose example, a normal question is something, where was the knife present? But in leading question, it will be like, was the knife present in front of the house? This is like an yes or no question. There is no reason to be explained. Nextly, cross-examination, where the witness will be questioned by the opposite lawyer. Third one is re-examination. Once cross-examination is done, the witness will again be re-questioned by the lawyer of his side, so that he can clarify or correct any mistake of misunderstandings or something. Nextly, questions by judge. A judge can question any time at any stage of the procedure. He doesn't have any particular stage to be questioned. Some of the important terms of medical ethics. Firstly, novus actus intervenens, which means unrelated actions intervening, where a person is responsible not only for his actions but also for the result of his actions. Like this happens especially in medical field because of negligence, where a doctor, for example, leaves a swab or any surgical instrument like scissors during surgery, this later may cause some infections or death. Then the doctor will be held responsible for the act. So this is novus actus intervenens. Next, coming to the term res ipsa loquitur, which means the thing speaks for itself. Like in case of a negligence act where the patient complains in the court, they doesn't require to prove any evidence. They don't have to search for the evidence because the negligence itself acts as the proof. That's what res ipsa loquitur mean. Next, coming to res judicata, which means a matter already judged. Under the section of 300 CRPC, a doctor cannot be charged more than once for the same offense by a patient. If so, the patient wants to change, then they can go for the appeal in the higher court. Next, coming to res indicata, which is considered to be the limitation, where filing of complaint for any damage that is caused due to the negligence should be within 2 years. After 2 years, this is not considered to be valid. Next, coming to the term malpraxis, which means professional negligence, where this is absence of reasonable care or some skillful negligence, like doing something which should not be done or not doing the necessary things that are to be done. This sometimes lead to injury or death also. Then that is called as malpraxis. Next, coming to the term euthanasia, which means mercy killing, where a patient who is having very painful disease or who has disease that is incurable will be given a painless death. So that is called as mercy killing. Next, coming to the term iatrogenic disease, where this disease would result because of drug administration or any surgery or diagnosis and treatment. The disease because of these things is called as iatrogenic. Next, coming to the term malingering, which means the consciously planning or pretending to have some disease which is not, like to gain some profit. Like you can take the example when we used to study in our schooling days, we give some fake sickness, like we act as if we are not feeling well to skip our school, right? So that is the best example you can take. So this is all about the medical ethic terms. Later in the video, we'll be seeing about the acts and sections. Stay tuned.
Finally, ending up with the quote, believe in yourself, which is the main ingredient of success. Don't lose your hope. Keep that confidence in you always. Thank you for watching the video till the end. If you like the video, kindly put a like, subscribe for more and more videos.